Mr. Ambedkar, when he was in the Constituent Assembly debates, when the question arose as to whether we should provide for freedom of press in the Constitution or it should be merely freedom of speech and expression to the citizens of India, he strongly advocated to not have the word press. And if you see the Indian Constitution 19(1)(a), it has a freedom of speech and expression, and which is guaranteed to every citizen of this country. So it's not a guarantee only to the press, it is a guarantee to every citizen of this country. Now, the significance of this difference is that the framers of the Constitution felt that press is very much a subset of the people of this country, and the freedom of the press will always be included in the freedom of speech and expression given to the people of India. So it was felt that there was no necessity for giving a separate freedom of speech to the press, because press were considered to be part of the people of the country itself. And that is why that difference is there in the Indian Constitution vis-a-vis the US Constitution. Now, the US Constitution was drafted in a short period of time, did not have so much of consultation, and there was a problem of getting it ratified also, because there was a necessity to get it ratified by the states, and there was a huge resistance because the states were worried that the federal structure may be compromised by giving too much powers to the central government there, to the president. So that is why this outcry, and that is why these 10 amendments which came as Bill of Rights. In the Bill of Rights, the US Constitution, of course, the first amendment talk of freedom of religion, and that the state shall not participate in religion, and also the freedom of speech and expression to the people as well as to the press. Now, this amendment to the US Constitution became the subject matter of several litigations in the US. And I'd like to deal with those litigations first before coming into the Indian Constitution and how the Supreme Court had the occasion to deal with the question of freedom of speech and expression, and what are the notable judgments on that. One of the very important judgments in the US Constitution by the US Supreme Court are related to, one of them is Edwards versus South Carolina. In this case, what had happened was that 187 black students were convicted by a magistrate's court of breach of peace for peacefully assembling in South Carolina government. The purpose was to submit a protest of grievance to the citizens of South Carolina and to the legislative bodies of South Carolina. During the course of peaceful demonstration, the police arrested the students after they did not obey the orders to disperse, something like a 144 order. The students were convicted of breach of peace, and after the convictions were affirmed by the state Supreme Court, the students fought further review. They contended that there was a complete absence of any evidence of commission of offense, and that they were thus denied due process. Now the question arose, did the arrest and conviction of the marchers violate their freedom of speech and assembly and petition for redress of their grievances as protected by the First and the 14th Amendment? And the conclusion that was held by the Supreme Court was that the due process clause of the 14th Amendment allows the free petition clause to extend to the states as well as federal government. And in an 8-1 majority decision authored by Justice Potter Stewart, the court reversed the criminal conviction of the blacks. It was clear to the court that in arresting, convicting, and punishing the students under the circumstances disclosed by the record, the state infringed the students' constitutionally protected rights of free speech, free assembly, and freedom to petition for redress of their grievances. Now, why this is important? Because unlike the Indian Constitution, where there is an Article 19(2), which gives the state to provide for certain laws to restrict the freedom of speech and expression. In the US Constitution, there is no such similar caveat. of in what cases the freedom of speech and expression can be abridged. So the courts have to, by a judicial process, devise by their judgments, have to decide as to what can be said to be a part of free speech and what will be considered to be something which can be said to be controlled by the state. Now, the interesting part is that in India, when 19(1)A was originally drafted, 19(2) did not have public order as a ground or a basis for making a law to control free speech. And that is, and one of the judgments, the very early judgments of the Supreme Court said that since there is no control by the state on the ground of public order, the very few laws will pass the muster of saying that there should be said to be in conformity with Article 19(1)A. So the First Amendment brought in public order by including this word in Article 19(2). So 19(2), whereas the First Amendment in our country was, because our constitution itself was very elaborate and very, very detailed, unlike the US Constitution. So our First Amendment brought in a certain amount of control on this freedom of speech and expression, which was originally given by the constitution makers. Whereas in the US Constitution, this freedom of speech and expression was brought in for the first time by the First Amendment. So it's a very contrast if you look at it that way. The First Amendment in India, of the Indian Constitution, vis-a-vis the First Amendment of the US Constitution, because the US Constitution brought in the freedom of speech, and in India you can say in some way that the freedom of speech and expression, which was a little more absolute, was made a little more conditional. And it was held that there could be laws which could which could regulate the freedom of speech and expression if the freedom of speech and expression amounted to public disorder, so to say. Now, to take the law as it evolved in the United States forward, the other important judgment is of New York Times versus United States, and the question really arose as to whether the Pentagon Papers, which were by a executive order, was President Nixon has claimed executive authority to force the Times to suspend publication of the Pentagon Papers, saying that this was a secret document and could not be published in the newspapers. And the US Supreme Court in 1971 held that this was part of the First Amendment, and this was something which was guaranteed to the people of the United States. And a very interesting paragraph is there that after 182 years of the drafting, I'd like to read that paragraph. Our government was launched in 1789 with the adoption of the Constitution. The Bill of Rights, including the First Amendment, followed in 1791. Now, for the first time in 182 years since the founding of the Republic, the federal courts are asked to hold that the First Amendment does not mean what it says, but rather means that the government can halt the publication of current views of vital importance to the people of this country. So it's a very interesting judgment. After 182 years, the court is being asked to say that please read the First Amendment as not at what it is saying. So then the court goes on to say, in seeking injunction against these newspapers and in presentation to the court, the executive branch seems to have forgotten the essential purpose and history of the First Amendment. When the Constitution was adopted, many people strongly opposed it because the document contained no Bill of Rights to safeguard certain basic freedoms. They especially feared that the new powers granted to the central government might be interpreted to permit the government to curtail certain freedom of religion, press, assembly, and speech. In response to an overwhelming public clamor, James Madison offered a series of amendments to satisfy citizens that these great liberties would remain safe and beyond the powers of the government to abridge. Madison proposed what later became the First Amendment in three parts, two of which are set out below, one of which is proclaimed. People shall not be deprived or abridged of the right to speak, to write, or to publish their sentiments, and the freedom of press as one of the great bulwarks of liberty shall be inviolable. And then they say, the judgment went on to say, the Congress shall make no law abridging the freedom of the press. Both the history and the language of the First Amendment support the view that the press must be left free to publish news, whatever the source, without censorship, injunctions, or prior restraint. The First Amendment, the founding fathers gave the free press the protection it must have to fulfill the essential role in our democracy. The press was to serve the governed, not the governors. The government's power to censor the press was abolished so that the press would remain forever free to censure the government. The press was protected so that it could bear the secrets of government and inform the people. So that's the expanse with which they said that this First Amendment should be construed. And that is how they said that this publication definitely is part of the free speech guaranteed by the First Amendment, and it can't be taken away by an executive authority. In India, we had the occasion to consider 19(1)(a) in a case where the law on sedition was challenged. And by a constitution bench judgment of 1962, which is 62 supplementary to SCR 769, in Kedarnath Singh, the Supreme Court said that sedition will not be held to be, will not be quashed, as it does not violate the 19(1)(a), but it also simultaneously read down the sedition laws or interpreted the sedition laws to mean that it can't in any manner control the right of the press or the right of the people of this country to speak fearlessly. So how they balanced the two competing issues. One was a conviction for somebody who is wanting to incite violence or is wanting to speak against the government in very vociferous terms, vis-a-vis the right to free speech. They balanced it by saying that the 19(1)(a) protection it will be taken away the moment the free speech results in inciting public disorder or inciting violence. So they say the limits of free speech will be only to the extent that you do not incite public disorder or incite violence. If whatever you may say, however critical you are, and one more thing which they said in this judgment was that the criticism can be of the leaders who are ruling the government. The criticism, if at all, to come into the ambit of sedition will be only if it is against the government in power and not the people manning the government. So that's a very important distinction. Today you may say that the Home Minister or the Prime Minister has done X, Y, Z wrongly. It does not mean that you are criticizing the government, you are criticizing the individual who is sitting in the government. Criticizing the government will be the authority of the government itself. So that is a very important distinction which Kedarnath Singh laid down, and that is even following today, is being followed today, and is considered to be a very important safeguard to the people of this country to speak freely. I would like to, it's such an important topic that I have something written down which I would like to read. So Brandis in Whitney versus California in 1927 said very interestingly that the greatest menace to freedom is an inert people, that public discussion is a political duty. It is hazardous to discourage thought, hope, and imagination, that the path of safety lies in the opportunity to discuss freely supposed grievances and proposed remedies, and that the fitting remedy for evil counsel is good ones. Then it was also said, the freedom of speech and expression has been characterized as the very life of civil liberty. In the Constituent Assembly debates, the Supreme Court in Bennett Coleman held that freedom of speech and of the press is the ark of the covenant of democracy, because public criticism is essential to the working of its institutions. Dissent and disagreement is the lifeblood of democratic ordering. We must not distrust or suspect dissent or disagree with it. In a democratic republic, it is not only the right but also the duty of the people to oversee the functioning of all institutions. In this function, the media has to play a very important part. Every important issue needs to be vigorously debated by the people and the press. It was to enable the people and the media to vigorously perform this role that, following the American Constitution, the Indian Constitution conferred fundamental right under 19(1)(a) to have freedom of speech and expression. The Parliament can impose only reasonable restriction on these fundamental rights. Then 19(2), I've already explained. In Maneka Gandhi, in 71 SCC, the Supreme Court also held that democracy is based essentially on free debate and open discussion. For that, it is the only corrective of the government action in a democratic setup. If democracy means government of the people, by the people, it is obvious that every citizen must be entitled to participate in the democratic process. And in order to enable him to intelligently exercise his right of making a choice, free and a general discussion of public matters is absolutely essential. Then in Rangarajan versus Jagjeevan Ram, 89(2) SCC 574, Supreme Court said, democracy is government by the people via open discussion. The democratic form of government itself demands from its citizens an active and intelligent participation. Public discussion with people's participation is a basic feature and a rational process of democracy which distinguishes it from all other forms of government. In a democracy, it is not necessary that everyone should sing the same song. Now, why this judgment I am quoting and why I am reading from this, I'll explain later. That today we are seeing, because of the way the social media is controlling our lives and our day-to-day affairs, that anybody who is critical of any action of the government, is immediately branded as anti-national, and that is where our democracy is in very serious threat. And that is why I say, and I'll deal with this a little later, why these judgments are very, very important, and why it is important to reiterate that everybody should not sing the same tune. The very fact that you are wanting to have a different view from what the government is doing or is saying does not mean that you are anti-national, does not mean that you are anti-democratic. It merely means that there is always a other view possible, and please be tolerant of that view. Please be, mindful of that view and take that view into consideration in the larger decision-making process. And I personally felt that what happened to these migrant laborers is an issue which we really have failed as a nation in this pandemic crisis. And anybody who talked about the migrant laborers was termed even by the Supreme Court, by the Solicitor General, as vultures, etc., which is very, very unfortunate. I mean, this really, really undermines the great democratic traditions of this country and the great democracy that this country has been always conceived to be by the world. So similarly, in Sakal Papers versus Unif India, Mudolkar J said, the court must be ever vigilant in guarding perhaps the most precious of all the freedoms guaranteed by our constitution. The reason for this is obvious. The freedom of speech and expression of opinion is of paramount importance under a democratic constitution, which envisages changes in the composition of legislature and government and must be preserved. Priority of free speech, 1918 takes over 1902. In the Rangarajan case, concerning the censorship of the film Ore Gramathli, the court indicated how the balance is to be worked out. So this is where what kind of ways in which the 19(1)(a) right can be controlled under 19(2), and Supreme Court says there does indeed have to be a compromise between the interest of freedom of expression and reasonable restriction under Article 19(2). But we cannot simply balance the two interests as if they are of equal weight. This is very important. as if they are of equal weight. Our commitment of freedom of expression demands that it cannot be suppressed unless the situations created by allowing the freedom are pressing and the community interest is endangered. The anticipated danger should not be remote, conjectural, or far-fetched. It should have proximate and direct nexus with the expression. The expression of thought should be intrinsically dangerous to the public interest. In other words, the expression should be inseparably locked up with the action contemplated, like the equivalent of a spark in a power keg. In Reliance Petrochemical in 88, 4 SEC 592, the court held there must be a reasonable ground to believe that the danger apprehended is real and imminent. The Constituent Assembly debates, I want to quote from them as well. When it was discussed, as I told you earlier also, the Indian Constitution failed to add 4 words and of the press to the article guaranteeing freedom of speech and expression. While discussing the freedom of press in the Constituent Assembly, Dr. M. Vikas said thus, and I'm wanting to quote what I've already said earlier. The press is merely another way of stating an individual or a citizen. The press has no special right which are not given to or which are not to be exercised by the citizens in his individual capacity. This philosophy seems to be inspired from a decision of Arnold versus King Emperor of 1914, wherein it was held that a right flowing from the freedom of speech and expression, the liberty of press stands on no higher footing than the freedom of speech and expression of a citizen, and no privilege attaches to the position of the press distinct from the right of the citizen. So the people in the press also exercise the right which is given to every citizen of this country. The freedom of the press, while not recognized as a separate freedom under fundamental rights, is folded into the freedom of speech and expression. The freedom of press serves the larger purpose of the right of people to be informed. The survival and flowering of Indian democracy owes a great deal to the freedom and vigor of our press. Then in Ramesh Thapar versus State of Madras, 1950 Supreme Court 124, it was held. One of the most sophisticated views on the blessing of free press was given by Justice Patanjali Shastri in this case, who spoke eloquently about the right of free press. Freedom of speech and expression included propagation of ideas, and that freedom was ensured by the freedom of circulation. Freedom of speech and of the press lay at the foundation of all democratic organization, for without free political discussion, no public education, so essential for proper functioning of the process of popular government is possible. In Indian Express versus Unit of India 85-1 SCC, Supreme Court said, in today's free world, freedom of press is the heart of social and political intercourse. The press has now assumed the role of public educator, making formal and non-formal education possible on a large scale, particularly in the developing world, where television and other kinds of modern communication are still not available for all sections of society. So this was in 1985. Today, of course, it's very different. The purpose of the press is to advance the public interest by publishing facts and opinions, without which a democratic electorate cannot make responsible judgments. Newspapers, being purveyors of news and views, having a bearing on public administration, very often carry material which would not be palatable to government and other authorities. Similarly, in Union of India versus Association of Democratic Reforms 2002, 5 SCC 294, Supreme Court said one-sided information, disinformation, misinformation, and non-information all equally create a uniform citizenry which makes democracy a farce. Freedom of speech and expression includes the right to impart and receive information, which includes freedom to hold opinions. And then coming back to the First Amendment, the actual wording says, the Congress shall make no law of the US Constitution. This is of the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting free exercise thereof. So this is relating to religion, or abridging the freedom of speech or of the press or the right of the people, peaceably to assemble and to petition the government for the redress of grievances. The First Amendment's protection of speech and expression is central to the concept of American political system. It provides the people with the marketplace of ideas. Concurring in Whitney versus Lord Brandeis, I've already said that freedom to think is the actual words of freedom to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth. Freedom of speech is linked not merely to such grandiose ends as service of the democracy or search for truth. Freedom of speech has value on a more personal and individual level. Freedom of speech is part of human personality itself, a value intimately intertwined with human autonomy and dignity. The First Amendment serves not only the needs of the polity but also those of human spirit, a spirit that demands self-expression. And this is quoted from Procureur versus Martinez, 1974. Then if you come to the freedom of speech and expression, some of the important judgments of the Supreme Court of the US. Freedom of press is a fundamental liberty guaranteed by the First Amendment. The framers of the First Amendment purported to embrace the notion derived from William Blackstone that a free press may not be licensed by the sovereign or the otherwise restrained advance of publication. Then in Neer versus Minnesota, 1931, this was the US Supreme Court's first decision to invoke the Free Press Clause, and it established a fundamental precept of constitutional law that once the press has gotten its hand on information that it deems to be newsworthy, the government cannot prevent it from publishing that information. Thus, it ratified the Blackstonian proposition. The central meaning of First Amendment was carved out in 1964 in New York versus Sullivan. The court in this case held that the First Amendment embraces a rejection of the law of seditious libel, and the First Amendment protects the publication of truthful information about matters of public concern, not just from prior restraint, but also from subsequent punishment. Now, if you will just contrast it to the sedition law in India, in sedition law also, there is an exception which carves out that if you have got an information which is based on some information or on some truth, then that is otherwise exempted from even the charge of sedition. So, similar is the ruling in Sullivan. Then there is another very interesting extract in the same case of the US Supreme Court. The general proposition that freedom of expression upon public question is secured by the First Amendment has long been settled by our decisions. It is a prized American privilege to speak one's mind, although not always with perfect good taste, on all public institutions. And this opportunity is to be afforded for vigorous advocacy, no less than abstract discussion. The First Amendment, said the learned judge had, presupposes that right conclusions are more likely to be gathered out of a multitude of tongues than though any kind of authoritative selection. To many, this is and always will be folly, but we have staked upon it our all. The constitutional protection does not turn upon the truth, popularity, or social utility of the ideas and beliefs which are offered. As Madison said, some degree of abuse is inseparable from the proper use of everything, and in no instance is this more true than that of the press. The erroneous statement is inevitable in free debate, and it must be protected in the freedom of expression are to have the breathing space that they need to survive. This is true even though the utterance contains half-truths and misinformation. Such repression can be justified, if at all, only by a clear and present danger of the obstruction of justice. This celebrated decision of the US Supreme Court has been referred to by the Supreme Court of India in Rajgopal versus State of Tamil Nadu. Then in Smith versus Daily Mail publication in 1979, Sullivan, the cases that followed, it stand for the proposition that First Amendment protects the publication of truthful information about matters of public concern, not just from their prior restraint, but also from subsequent punishment, at least in the absence of demonstrated need to vindicate a competing government interest of the highest order. This formulation has come to be known as the Daily Mail principle, after the Supreme Court's 1979 decision, in which the court held that a newspaper could not be liable for publishing the name of a juvenile offender in violation of a West Virginia law, declaring such information to be private. The protection against subsequent punishment for reporting the truth afforded by the Daily Mail principle are not absolute, but the barriers to the government regulation of the press are set extremely high. Incidentally, in India also, you can't publish the name of a juvenile. But fortunately for us, we have not gone that far, and we have not held that law to be unconstitutional. And even today, if there is a juvenile who is in conflict with law, neither can his face be published, nor can his name be published, or his parentage be disclosed, or his address be disclosed. And similarly, is of a woman who has suffered some kind of either a rape victim or etc. Her identity also cannot be disclosed. Similarly, in Bartnicki versus Whopper 2001, the court held that even when a statute is directed at deterring unlawful conduct and not on penalizing the content of press reported, nevertheless constitutes a naked prohibition on the dissemination of information by the judges, that it is fairly characterized as a regulation of free speech in violation of the First Amendment. In so holding, the court ushered in a new century of First Amendment jurisprudence by reaffirming both the Daily Mail principle, the fundamental right of a free press to disseminate truthful information about public matters, and the central meaning of First Amendment on which it is based, Sullivan's recognition that the freedom of expression upon questions is secured by the First Amendment. So that debate on public issues should be uninhibited, robust, and wide open. Now, incidentally, there was an incident in the US where there was a judgment by the House of Lords. And one of the newspapers on the very front page reported that three old fools, and they wrote about the judgment as something which was a trash judgment, and it was criticized. When somebody mentioned to the judges of the House of Lords that this is what the newspaper is saying about your lordship's judgment, the judges very candidly took the view that old is a matter of fact, that we are old, nobody can dispute that, and that we are fool is a matter of perception. So it's definitely a part of free speech for the media to say this kind of a thing, and we need not have to be extra, sort of critical of these kind of. But unfortunately, our Supreme Court or our courts are not that generous in accepting this kind of view, which I think is not correct, because we should be open to criticism, and we should be. Now, again, if you come back to the Indian jurisprudence, Express newspapers, 1958 Supreme Court 58, Justice Bhagwati said that the fundamental right to the freedom of speech and expression enshrined in our Constitution is based on the provisions of Amendment 1 to the Constitution of the United States. The provision with regard to freedom is quite similar in both legal systems. That being said, the freedom of press in the US Constitution has two positive features. That is, freedom of press is specifically mentioned therein. No restrictions are mentioned on the freedom of press, unlike like we have in 1902. With respect to India, the Supreme Court has held that there is no specific provision ensuring freedom of press separately, but this freedom of press is regarded as a species of which freedom of expression is a genus. It is significant to notice the difference between the US Amendment and 19.1a read with 19.2. The first important difference is the absoluteness of the US Amendment. The Congress shall make no law which abridges the freedom of speech. Whereas in India, it is more of a right which extends to certain levels, and reasonable restrictions are well defined. Free speech is meaningless unless it has space to breathe. It is important to note that the false statements made honestly are equally a part of freedom of speech. The Supreme Court of India applied the famous doctrine of the New York Times versus Sullivan standard of American constitutional law against public officials. Accordingly, statements made against persons in public cannot be considered defamatory unless they are made with actual malice. The reason for this is very simple. Democratic governance mandates the strict scrutiny of public official duties. The consequence of the extent of freedom in the US Constitution is that ideas or expressions which may be offensive or hurtful or even racial can be expressed freely. The other side of the coin suggests that it leads to healthy debate on public issues. The government is not permitted to make decisions about what ideas may be expressed and what ideas may not be expressed. The constitutional guarantee of freedom of expression under the First Amendment means that freedom of expression in the fullest sense. With regard to India, the debate on whether freedom should be inserted in the Constitution as an individual right is heavily discussed by the Constituent Assembly. The Constitution came to the conclusion that such a provision was not necessary. Dr. Ambedkar in the debate said, the editor of a press or the manager is the citizen, is all citizens, and therefore when they choose to write in newspapers, they are merely exercising the right of expression. And in my judgment, therefore, no special mention is necessary of the freedom of the press at all. Second, whereas the US amendment makes of freedom of speech and of the press without any reference to expression, Article 19(1)(a) speaks of freedom of speech and expression. So the expression is not there in the US amendment without any reference to the press. Third, under the US Constitution, speech may be abridged, whereas under our constitutional reasonable restriction may be imposed. Fourth, under our Constitution, such restrictions have to be in the interest of 8 designated subject matters. That is, any law seeking to impose a restriction on freedom of speech and expression can pass muster if it is proximately related to any of the 8 subjects set out in Article 19(2). Now, the dilution of the apparent differences. Insofar as the first apparent difference is concerned, US Supreme Court has never given literal effect to the declaration that Congress shall make no law abridging the freedom of speech. The approach of the court is secondly stated in one of the earlier US judgments and continues even today. That is Chaplinsky versus New Hampshire, 1942. Allowing the broadest scope to the language and purpose of the First Amendment is well understood that the right of free speech is not absolute at all times and under all circumstances. There are certain well-defined and narrowly limited classes of speech, the prevention and punishment of which has never been thought to raise any constitutional problem. These include the lewd and the obscene, the profane, the libelous, and the insulting or fighting words, those which by their very utterance inflict injury or tend to incite on immediate breach of peace. It has been well observed that such utterances are no essential part of any exposition of ideas and are of such slight social value as a step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and modality. So even though there was no Article 2, the court devised its own method and said that everything is not free in our country. And there could be certain limitation. So far as the second apparent difference is concerned, the American Supreme Court has included expression as part of freedom of speech, and this court has included the press as being covered under 19(1)(a), so that as a matter of judicial interpretation, both the US and India protect freedom of speech and expression as well as press freedom. So although their expression is not there, press is there. In our case, press is not there, expression is there. But both have always construed to include both. So expression is included there and press is included here, even though not expressly stated in the First Amendment there or in our Constitution here. Insofar as the abridgment and reasonable restriction are concerned, both the US Supreme Court and this court have held that a restriction in order to be reasonable must be narrowly tailored or narrowly interpreted so as to abridge or restrict only what is absolutely necessary. It is only when it comes to the 8 subject matters that there is a vast difference. In the US, if there is a compelling necessity to achieve an important government or social goal, a law abridging freedom of speech may pass muster. But in India, such law cannot pass muster if it is in the interest of general public. Such law has to be covered by one of the 8 subjects mentioned set out in 19(2). If it does not, it is outside the pale of 19(2). The court must strike down such law. In Kameshwar Prasad versus State of Bihar 62 Supplement 3 SCC 369, its Supreme Court said, as regards these decisions of the American court, it should be borne in mind that though the First Amendment to the Constitution of the United States, reading Congress shall make no law abridging the freedom of speech, appears to confer no power on the Congress to impose any restriction on the exercise of the guaranteed right, still it has always been understood that the freedom guaranteed is subject to police power, the scope of which, however, has not been defined with precision or uniformly. The Indian courts have been guided by the decisions of the US Supreme Court when it comes to understanding the impact and the content of freedom of speech. The Indian Express newspapers, Bombay versus Union of India, that same judgment I referred earlier, also Venkataramani said, while examining the constitutionality of a law which is alleged to contravene 19(1)(a) of the Constitution, we cannot, no doubt, be solely guided by the decisions of the US Supreme Court. But in order to understand the basic principles of freedom of speech and expression, the need for that freedom is in a democratic country, we may take them into consideration. Now, there is a very interesting, the strategic lawsuits against public participation to the KICS, criminal, intimidatory, coercive knockouts of strategy. So this is how law has evolved globally. In the 80s, human rights activists noticed something called the strategic lawsuits against public participation, a multinational company strategy for suing performance of public participation. This was widely used against those who dare to criticize the product of a company, saying that it posed a danger to health or environment, and were sued both for injunction and heavy damages. From SLAPS, which is the strategic lawsuits against public participation, we have seemed to have moved on to KICS, instance of criminal prosecution of journalists for offense of sedition under 124A, defamation under 505 IPC, etc., are now being lodged very recklessly. There is a recent trend in the Indian democracy where citizens and media are terrorized with sedition and defamatory laws. Thus, criminal law is used for unlawful intimidation or action against the dissenting other. Large number of instances have happened where journalists were arrested, had FIRs registered against them, and summons or show cause were issued. Recently, I had the privilege of appearing for Mr. Vinod Dua, against whom 2 FIRs were registered, one in Delhi and one in Himachal. And the Delhi, of course, in spite of his having a anticipatory bail granted to him by the lower court, the High Court, I would salute the High Court for staying the FIR completely as holding it to be a complete abuse of the process of law. And even for the Himachal, the moment I got the order of stay from the Delhi High Court, the Himachal police came to his residence the very next day in a FIR which was registered about 40-45 days earlier, and to ask him to participate in a investigation of a case for sedition. And what is sedition or what? Sedition for reporting that the government is doing XYZ not correctly. That's all that he has said, nothing more. And the Supreme Court was kind enough to hear this petition on a Sunday. And since Mr. Dua had volunteered to join online, so the court said that for the time being, we are not staying the investigation, but there can be no arrest. And that protection is continuing. The matter is again coming 2 days from now. And of course, now that the police is again trying to, sort of make out a case that he's not cooperating with the investigation, we have filed a further application that the FIR itself should be stayed, because these are methods of even the continuance of an FIR of this kind, according to me, amounts to the suspension of the fundamental right guaranteed under 19(1)(a), which journalist can fearlessly report against the government if he has an FIR of this kind continuing against him, or if he has a threat that such FIRs can be registered against him. So, according to me, that is where this intolerance is coming in today, and I am actually quite distressed that even in friends groups and family groups now you will find very diverse and extreme views coming. So people who support the government are considered to be national. People who don't support the government are being considered as anti-national, and everything that the government does, the people who are supporting them will try and find some kind of method of trying to justify that this action, although it may be completely flawed, to find some kind of a basis. If they don't get any rational basis, then they will say that there is something supernatural in what is being done to justify the decision of the government. So, for instance, when the Prime Minister said that you chant or you beat thalis for this thing for giving credit to the frontliners in the COVID fight, although the Prime Minister himself did not say so. People went on to say that this chanting will make the pandemic go away. So that's the kind of absurdity we are going to justify a decision of the government by the pro-government people. And anybody who says that this was not necessary are immediately branded as anti-national. So this kind of intolerance is very, very sort of dangerous for our democracy. We are still, according to me, a progressing democracy. We have still to evolve. We're still evolving, and there is a lot we have to learn from the rest of the world. And I feel that this case which was registered against Mr. Dua, or similar cases which are being registered against the people of the press, is something which will take this country back from the front line of democratic functioning that we were considered to be some years back. And we were. It's very surprising that India in 2019 is ranked as 140 out of 180 countries on the World Press Freedom Index. This number fell to 142 in 2020. So just imagine 140, 180 on the World Press Freedom Index and going to 142 in 2020. So this only shows how intolerant we are, or how intolerant the government is, or how insensitive or how illogical and how reckless the police is for registering FIRs of this kind against the people of the press. According to Reporters Without Borders, which is an organization which releases the Press Freedom Index in India, there have been constant press freedom violations, including police violence against journalists, ambushes by political activists, and reprisals instigated by corrupt local officials. Instances of criminal prosecution of journalists for offences of 124 defamation, so and so, are on the rise. So this is all taking us backwards in the World Press Freedom Index. So journalistic freedom, according to me, is at the very core of the freedom of speech and expression, because you and I may have a view, but we are not able to take this view to the people, because if we talk in a drawing room, we are talking within friends or we are talking within family. But it is only the press who take the views or the diverse views to the people at large. So that is why the freedom of press, according to me, is the very core of this freedom of speech and expression, and it should be hugely respected in this country. And any effort to curtail this freedom should be abhorred and should be strongly commented upon by the courts of this country. This, according to me, is a very important topic, and I think that if anybody has any questions, I would readily answer.
Sir, thank you, sir. Thank you for especially touching the pain of all of us who have got we see daily fights in our family WhatsApp groups. So
even I'm facing this in my family and friend both. So in fact, at one stage, some of the children exited the group. There was so much of difference in the family, and that is something which is very, very, unfortunate, I would say.
I completely understand, sir. Sir, to begin with, we are getting a large number of questions, but I'll invite Raj. He's got a couple of questions which he has got from some people who want to ask.
I have only one request. Actually, I accepted this talk. But I have actually some people at my home. So if you could just give me one or two questions, I'd like to just quickly and
Perfect. So I'll just start with inviting Raj. He'll ask one or two questions. Then we have one or two live questions, and then we can get this over. So
I'll be grateful, because I want to just
we'll do that, sir. We'll do that.
Thank you, sir. Thank you, Mir. So one of the questions asked by Mr. Alok Kumar, he's a senior partner at THS law firm. He asked this question: has Supreme Court been consistent in balancing between Article 19(1)(a) and 153(a) and 124(a)? Is the interpretation more on facts or personal perception of judges?
So, according to me, the Supreme Court has. It's a very interesting question, and I'll tell you, it's a subject which actually was not dealt with in Kedarnath Singh. In Kedarnath Singh, what had happened was that this person, he was a small-time politician. He had made some very, very damaging statements in Bihar, and he was convicted for sedition, and his conviction had been upheld. So when he came to Supreme Court, he challenged for the first time in Supreme Court, he challenged the virus of 124A itself, and he said that this law can't be justified as passing the muster of 19(1)(a). But so the Supreme Court went and balanced these two rights and said that the right, what you say cannot be protected if you go beyond a certain limit, and if you are within the limit, then it is an absolute right. But interestingly, in Kedarnath Singh, his lawyer did not argue on merits that what he has said will pass the muster, and it is not sedition. So the Supreme Court, if you read the judgment at the end, the Supreme Court says nobody has argued that, so we have no occasion. So they had to uphold the conviction only on that limited ground. So this is a very important aspect of advocacy, that when you argue a proposition on a purely legal proposition, a purely legal principle, you should also do that fallback argument of saying that even if this legal principle were to be interpreted in this manner, still my client has not, committed this offense. So, and after Kedarnath Singh, there has not been a very detailed judgment of this kind to balance these interests. So, really speaking, this question, probably the occasion has yet to come, and that is why in Vinod Dua's case, I have asked the Supreme Court to frame guidelines. And I've also said that, like you have said in the case of medical professionals, that FIR cannot be registered without the report of a committee. I have said that in the case of journalists also, FIR should not be registered without having a committee constituted by the Supreme Court. And I have suggested that it should be the leader of opposition, the Chief Justice, nominee of the Chief Justice, and the Home Minister of the state. So they should have the committee, and that kind of a committee only should vet a FIR to be registered or not. So this, according to me, this question, really speaking, will be answered in some time. And today, the principle has been very correctly laid down, but factual analysis has yet to be done.
Thank you so much, sir. So there's a follow-up question from Mr. Alok Kumar. He says that how do citizens understand the difference in approach of cases between, say, Vinod Dua and Arnab Goswami, sir? Just you covered this during your talk, but still, sir, what are your views?
So I would say if you were to rank the two telecasts, if anybody had the occasion to see both the telecasts, if you were to rank the telecast, Vinod Dua is completely just simply critical of the government, and he has not said anything which can be said to be inciting violence or that kind at all. But Arnab Goswami has been inciting passions of a particular community, and to that extent, even though in his case one can be said to be his degree to be a little higher, even then the Bombay High Court, if you see the recent judgment that they have passed, they have said that this also does not amount to inciting violence or inciting public disorder. So there also the FIR has been stayed. So ultimately the degree may be different in the two, but in both cases, according to me, the sedition law will not apply, and it can't be said that they are exceeding the limit given to them under the Constitution.
Thank you, sir. So we'll take one small question, and after that, I'll invite a couple of live questions. Mr. Satya Prakash, he asked the question, sir, do you agree with the statement that Press Council of India is a toothless tiger? Should PCI be given more power, sir? What are your views, sir?
According to me, definitely it is a toothless tiger, and according to me, the Press Council of India should have the chairman, especially, should not be appointed by the government. There should be some kind of a collegium appointing the chairman of the Press Council, and the powers should be very, very elaborate, and they should have a proper system of because there are a large number of things within the media which need not be said to be violative of the guarantee under 19(1)(a). Sorry, may not be something which can be said to be violative of 19(2), so it's not permissible under 19(1)(a). But at the same time, there are a lot of unethical things being done by the media, and to that extent, I think the press council should have more authority to say that where the media is being used as a tool for to achieve any purpose. So whether I'm not wanting to take side, whether it be Vinod Dua, whether it be this India Today TV, or whether it be Arnab Goswami, whichever extreme you may be, there has to be a certain amount of balancing in your reporting. And if you don't do that balancing, then you're not practicing as media at all. Then you are acting as a tool of some interested groups. And that is where the press council authority can play a very important role.
Thank you, sir.
Thank you, sir. Sir, we have got a couple of live questions. I'll invite Mr. Abhishek Kaushik to unmute himself and ask the question. Mr. Kaushik.
Good afternoon, sir. Thank you for sparing time on Sunday and speaking to us. It has been a very rich experience today. Now, my question pertains to sitting and retired judges of Apex Court. Till the time they are on throne on the dais, they make left, right, and center remarks. I don't want to go there. You are very well aware about. And when they are off the chair, recently you would have read about article. I don't want to name him. I'm sure you are also aware. Where he writes article about a judge who has retired, Chief Justice who has retired, joined Rajya Sabha, and he makes his own comments about him. Then he makes comments about other sitting judges who were part of the bench, sitting with him, as if the entire judiciary, the Apex Court, has been sold out to a particular government or some other person. Now, we have seen in past that one of the High Court judges, when he had the audacity to do that, the Supreme Court came down heavily upon him, and he was also incarcerated for what he did. But till now, with this judge, except for one of the meetings in which he was summoned to court and he apologized and the matter subsided, in the present controversy, no action whatsoever is being taken. The question would be, would this not encourage non-Supreme Court judges also to write such a thing against the Supreme Court or verdicts of Supreme Court, and instead of criticizing, assign malice to the decisions of the Supreme Court? What should be the action?
I totally agree with you that judges of the Supreme Court, whether during their service or during their tenure, when they sit in that office, they should only speak through the judgments. And I know the person that the honorable judge that you are retired judge that you are referring to, even as a sitting judge on the Supreme Court, I remember in his court, if he used to see the media, some persons of the media entering his court, he would make some reckless statement just to get onto the front page of the newspaper. So this tendency is not correct. As a sitting judge also, you should not be making loose comments just to get into the media. And after retirement, I also agree with you, after retirement, judges should not open out like this. If you did not, especially if you did not do something by writing a judgment or by doing something while you were part of the institution, by getting out of the institution and criticizing against the institution undermines the authority of this institution, and it is not in good taste, I would say. I'm not saying he can't do it. His right to free speech and expression is absolutely guaranteed, and he is no less citizen than the press or anybody else. But it is not in good taste for him to do it. It is only the tradition used to be, I think till about 10-15 years back, or maybe 15 years back, that judges only spoke through the judgments. They never tried to speak by making loose comments during the course of a hearing just to get into the media. But unfortunately, in the last 15 years, this trend has become very, very common of judges getting into the media by making loose comments. There are instances, and I have also commented very strongly, even when I was president of the Supreme Court bar, while the retirement of a particular Supreme Court judge came, and he had made some very loose comments in his hearing. I told him in his farewell speech, I told him that it is unfortunate that you have said something which there was something against the army, and it was a very, very damaging statement which was made. And you all will be happy to know that in that very farewell speech, he came to me and he called me and he said, Vikas, I did not mean to say this. I said, if you didn't mean to say this, unfortunately, the media carried it that way and nobody knows what is in your heart. So all the more reason for you to be careful of what you say. So, you know, these are things where as members of the bar and especially the Bar Association and the president, etc., they should be a check and they should be, you know, pointing this out more frequently that judges, what they're doing is not correct and that unfortunately, we are the only people in this country who can say something and, you know, be heard. Otherwise, anybody else who wants to say something, including the media, they are hauled up for contempt. So we don't have that kind of large-hearted judges like I mentioned of the House of Lords in the UK or anywhere else. So that is something which is not correct.
Sir, Mr. Purvish Malkhan has a question. Mr. Malkhan, please unmute yourself and ask sir your question.
Good morning, sir.
Hi, Purvish. How are you?
I'm good, sir. Thank you so very much. Sir, it had been an enlightening lesson on this Guru Purnima day from you. And I seek blessings from you and from my other teachers, Ravandes and other teachers present here on this Guru Purnima day, sir. Sir, my question is not related to or specific limited to 91A, but it's on the major aspect of the constitution and where I'm trying to find my answer on this for long now. My question to you is, sir, the legislatures, the parliament, the body has actually limitized the fundamental rights, what they have tried to constitute when the constitution was framed. In the very first amendment, the very same body which has enacted the constitution has limitized the fundamental right by insertion of 31A and 31B with schedule 9, maybe for the purpose of agrarian reform. But thereafter, we have seen that all sorts of laws, including all the subjects, are included within schedule 9 now. And the rights, the fundamental right has been made restrictive. Golaknath tried to make it liberal again, but then again it is restricted to basic structure, which I felt it to be golden carrot shown to us in order to take away our liberty. So what, in your opinion, sir, my question is that whether this vague concept of basic structure is correct, or what Golaknath has said that law is law, even includes constitutional law, would be the correct interpretation?
Well, according to me, basic structure is definitely a very inviolable part of the constitution, because if you don't consider basic structure as something basic, then ultimately can it be said that the parliament in its power to amend the constitution can convert this constitution into something very different than what the constitution makers had advised? So according to me, this basic structure doctrine has rightly been determined by the Supreme Court, and it is here to stay. In fact, with passage of time, we should clarify what all should be considered as basic features, because that process is still on. We have still not decided what all is the basic structure. We decide once in a while, oh, this is basic and that is basic, but that elaborate discussion is still to be. And I would be very happy if Supreme Court were to, in some judgment, comment that what all according to it is basic structure by commenting on the entire constitution at one go.
Amit Sharma, please unmute yourself and ask.
Can I be excused
afternoon,
after this question?
A very good afternoon,
Two more, sir.
Good afternoon.
Sir, my question, first of all, let me wish you a happy Guru Purnima, sir, and to Mr.
Thank
Ravandes, sir.
you. Thank you so
And
much.
I personally know that you both believe in Karma Yoga, so I'm wishing you a happy Guru Purnima. So my question is that should we have some kind of training in the police reforms or the National Judicial Academy for the judges, so that they will be able to understand the real import of 19(1)A, and in that sense, these frivolous cases, these motivated cases can be minimized?
Well, I am very firm of the view that especially when the people join from the bar, whether it be in the lower court or high court or even Supreme Court, there always should be a certain amount of orientation training and certain amount of, because you know that discipline that should come by after becoming a judge, that discipline has to be sort of inculcated right from the beginning. And also, when you decide what kind of cases to give to whom, you should also give that particular judge. So, for instance, when a judge hears a matter regarding, say, NDPS for the first time, he may have never done NDPS in his life. So, you should not expect a judge to be straight away taken into a new subject. There should be somebody to tell him how this law has evolved, and before he hears any case of a subject which he has not dealt with. So that kind of a training should be there, but unfortunately, the system that we have today, it's not possible unless the judges do it themselves by means of some kind of a self-regulation. Thank you, gentlemen. Thank you very much.
Thank you, sir. Unfortunately, because you have to go, we can't take any more questions. I'll invite Professor Hon'ble to give us his concluding remarks.
Sir, namaskar. Well, I could hear the kind of questions which are raised, and people began with wishing you first and followed by the question, which stands for not just your popularity, but it shows your richness, that you are within reach to them. And there are no reasonable or unreasonable restrictions on anyone to meet you. So I could make it out. Sir, there were a few questions which I could see, but I would not go to those questions. I'll just take 3 minutes to conclude. We always have understood right something as very powerful tool, but we have forgotten it is affirmative claim. It's not the power, because there is distinction between right vis-a-vis power. We also have been taught right is something without which we cannot survive as a human being. So again, we relate it with human rights, and which really challenges the very existence of the humankind, because it makes you, without it, you don't exist. So that corollary also we need to work upon. Now, being a student or the learner of law, I always feel that different school of jurisprudence give us different thought to understand that concept. But I relate when it comes to Article 19, Clause 1, Subclause A, and the further reasonable restrictions, it has to do more with the sociological school. Because sociological school says law is the medium which balances the conflicting interests. So whether it is individual interest, social interest, or state interest. But as you rightfully pointed out about India's stature when it comes to the international arena, 142, that is absolutely correct. And if you refer to that 142 as well, we come after few countries which are run by the dictators, means we come after them. So that also talks loud about it. And if we refer to the order of the Honorable Supreme Court dated January 10, 2020, wherein the court specifically ruled that an indefinite suspension of internet services would be illegal under the Indian law, and that orders for internet shutdown must satisfy the test of necessity and proportionality. So it talks about that you can put the restrictions, but they cannot be unreasonable. And I think over the period we are forgetting that, which you rightfully pointed out. And wherein the role of the courts become important, but before that, the role of the bar becomes more important as well, because we take it before the honorable court and then we argue and then we get this judgment. So as we are fortunate to have wonderful senior professionals like you who have been arguing these matters, we have heard. So people may have that branding, you are this side or that side, but we always have found that senior professionals are always on the law side. They do not have what is called right or the wrong side. So thank you very much for standing there and being there always. And we would be happy to have you to address further issues in future. But
thank you so much. Always.
I would like to thank you on behalf of Symbiosis International Deemed University and other partners, Lex Witness, K.T.S, the law firm, as well as SADGAMAYA. And both the wonderful students, Mr. Raj Kamal and Mr. Kumar Mihi. Over to you, Raj.
Thank you so much, sir.
Thank you, Raj. Thank you.
Thank you, sir.
It's always a pleasure to be on with all of you, and it's always also, you know, when you talk on this subject like this, is also you also refresh your own thing on that subject. So it's always very beneficial for both of us.
Learning from the legend of the professions, it's always an enlightening for all the participants. Sir. Thank you very much, sir.
Thank you.
For all the participants live, the video of today's session is available on the YouTube page of Symbiosis Law School. So whoever has missed out certain portions of the webinar can go and view it there, sir.
Thank you.
We'll be back again next weekend with some more legends in the profession. Thank you so much. Thank you.
Thank you, sir.
Thank you very much.
Mr. Hon'ble, seeking your permission to end the webinar now.
Yes, Mr. Akshay. Thank you.
Thank you so much.
Thank you, everyone.
Thank you.